Hi everyone, welcome back to LW1230, Business Law in Canada. I'm Paul Tilley, and in this section of Unit 1, we're going to look at our court system in Canada and how it is arranged and how it works. Okay, and if we look at our court system consists of many levels of courts. And here I've got a quick summary of how this works. Going from bottom to top, okay? We've got the provincial and territorial courts, which is the courts in Newfoundland. I'll slide as we move down. I'll show you that the provincial and territorial courts. Every province, every territory has their own set of courts. And these are I'm going to call them the courts of original entry, even though the provincial courts has different levels in and of themselves, but effectively, normally a court case would end up there first. We also have military courts for military employees. So if, for example, you are in the Canadian military, you do something wrong, you'll be tried in military court regarding military applications. Not something we have to worry about in general society as a general rule. The provincial courts are complemented with the federal court, which is that other branch over there. And the federal court has various branches as well. And you say, why do we have two levels of courts? Well, the provincial courts handle all the things that the provinces are responsible for, and the federal court handles all the things that the federal government is deemed to be responsible for as per the Constitution. So if you had a case that dealt with navigable waters, for example, navigable waters are the realm of the federal government as per the Constitution. So you'd end up going to federal court for that. Whereas the provincial courts will be interested in provincial legislation. Okay, so these are the courts of original entry. We also have little subcourts called the Tax Court of Canada. That's where you go if you want to fight Revenue Canada, for example. You'll notice that these courts, regardless of what the level of the court is, be it the military, the provincial, or the federal, there will be a court of appeal, which is a higher level. And this is where, if there was a judgment error in that lower level court, that higher level court could overturn it. And at the very top, we have what's called Supreme Court of Canada. Supreme Court of Canada is, as the name says, supreme over all of the courts. And it will only hear cases that it wants to hear. And so, for example, certain cases will make it all the way up to the Court of Appeal. And these cases will be looked at, and if the lawyers in those cases say, you know, this case has implications for Canada as a whole. If the judgments are contested in the appeal court, they can make a petition to bring it to the Supreme Court of Canada. And the Supreme Court of Canada will hear the case, and they will make a judgment on it that will ripple right down through the court system. So the Supreme Court only hears really important cases that relate to every citizen of Canada. So, for example, the abortion issue or equality issues, things that normally are fundamental in our Constitution. Courts hear both civil and criminal cases. As I spoke about earlier, criminal cases dealt with crimes and misdemeanors that offend the legal system and criminal law in Canada. We're not so much focused on that in this course. We're interested in business law, and business law is what we call civil cases, a wrongs of one person against another. Okay, so the civil is what we consider private. In other words, you and me are involved in a dispute. It's not something that the rest of the world need to concern themselves with. That's really the focus of the civil law. Criminal law is more or less we against the state. So, in any case, regardless of civil or criminal, we have something called the litigation process. Now, this applies more to civil, so I'll focus on it from a civil perspective. So, the civil action starts when individuals or corporations disagree on a legal matter. So a civil suit can also result if someone is injured or property is damaged. The person who sues is called the plaintiff. So the person who's done wrong is called the plaintiff, and the person being sued is called the defendant. The burden of proof always rests with the plaintiff, which is the person doing the suing. So the person doing the suing has to prove that they were wronged. So this is where we get into the innocent till proven guilty scenario. The person who brings the case have to prove they were wrong in some way. The person who is being sued really doesn't have to do anything. You're just kind of, they have to defend themselves, I'm sure. But the fact of the matter is, nothing's going to happen to them unless that there can be a burden of proof that is met by the person who is doing the suing. So any lawsuit goes through some distinctive stages. The first stage is called what we call the notice of action. The notice of action is where you are served with a summons, I'll call it. So that's someone will bring you personally, or register mail you, or whatever, a summons from the court. And so the plaintiff, the person doing the suing, files notice of action with the court. So I can go down to the courthouse today and create a notice of action. I could probably do it online. And that sets out the complaint against the defendant and the remedy that I'm looking for. So I'm suing you for damages, or I'm suing you to stop doing what you're doing, or I'm suing you for any number of things. So I had to basically tell the court, here's the person I'm suing, here's what they did wrong, and here's the damages I'm looking for. That notice of action then is taken by a court officer and bringing it to the person being sued. So the court officer then issues a claim by affixing a seal of the court and signing the pleading on behalf of the court. Copies are delivered or served on the defendant. So someone comes to you and you say, I've been served. You hear telling that terminology. That effectively means someone handed you a piece of paper that says you're being sued. So the defendant's job then, your job, if you're the one being sued, is to provide the court with a statement of defense. So you shouldn't ignore it. You shouldn't ignore it. You should say, no, I didn't do this, or here's my rationale. So if he or she doesn't do anything, the court will assume that the plaintiff's allegations are true, and the defendant will thus potentially lose by default. Now that doesn't happen very often, because if the court is serious enough, if the case is serious enough, then the defendant will respond. Okay. Then we move into a next stage, and the next stage is called discovery. Now, you got to imagine, this is the thing that bugs me about using the court. The court system is paid for by you and me. It is paid for by the taxpayer. And we don't want frivolous cases being brought to the court, because you could clog the system and people could sue one another for no reason whatsoever. So the situation has to be filtered. Useless vexile cases cannot tie up the court system. So effectively, this stage of discovery is an initial part that's done in order to weed out problem cases. So each party is entitled to an examination for discovery before the trial, and discovery is intended to clarify the claim against the defendant and lets each side examine the evidence that the other side intends to use in court. So it fills you in on what's going on, but it also gives you a chance to say, is this real or not? And the court system will say, is it real? Is it worth pursuing? Normally lawyers at this point, or you'll be advised to stop it, or whatever the case is at that time. If it passes through discovery and continues on, then it will go to trial. Now, the trials can take a while, because the fact is that our court system is not fast. It is clogged up. And so you'll be on the court docket you'll book a time in on the court effectively. And the court docket is online. You can go check it. My daughter's a real good one for checking that, see what's on the go. But you can go see the court docket. It is public. Seeing our legal system is paid for by the public, it is considered a public system. So during the trial, it's up to the plaintiff to present facts to support the claim against the defendant. So in a civil case, the plaintiff must prove that it is probable that the defendant is legally responsible or liable. Probable means greater than 50% chance. In a criminal case, the plaintiff must prove the case that is beyond a reasonable doubt. In other words, a much higher standard of proof has to be in a criminal case. You're not going to send someone to jail on, I think, right? So the trial begins when the plaintiff presents evidence against the defendant. The plaintiff may call witnesses to testify to the facts, papers, photographs, so on. The defendant then can cross-examine the plaintiff's witnesses to test the evidence. And the defendant then presents his or her own evidence, including witnesses, and the plaintiff can in turn cross-examine there. So the process is the person suing makes their case, and the person that's being sued gets to rebuff that. At the end, both the plaintiff and the defendant summarize their arguments. The judge must then consider the evidence presented before making a decision based on what's proven to be most probable. Again, most probable. So the judge then will take it away, think about it, consider it, and produce what's called a judgment. So if the facts justify a remedy, the plaintiff is seeking, the court will hold the defendant liable and basically award the damages. If the defendant is found not liable, the judge will dismiss the case. If the defendant is found liable, the judge may consider three things. How much the remedy should be. So, you know, the original plaintiff may say, I want to sue for $1 million, but the judge can think about it and say, no, $100,000 is enough. And, you know, the judge considers the facts and how to compensate. This remedy stage occurs next, and the remedy is the means for resolving the civil case. So there are three different types: monetary or declared remedies, or some form of injunction. Monetary remedy is really money, okay? You'll pay money, and the money could be in the form of damages, could be in the form of any number of things, but effectively it's a sum of money that is designed to put the person back in the original position. It's not necessarily a punishment. It's more like you can consider it more of a fine, okay? So, so these damages are different types, but effectively they involve dollars and cents. The judge can also declare remedies, which is simply state the rights of the parties. For example, when a court interprets it will decide who owns the property or land. The third type of one, which is common in labor relations cases, are injunctions, which is basically a stop doing that message. So is a restraining order that says that someone can or can't do something. You can get an injunction to stop your neighbor from burning garbage or to remove junk. So an injunction, you know, is given by the court, and it defines what you can and can't do, what you should or shouldn't be doing, which is, you know, court cases involving strikes, for example, grant an injunction to stop the strike or to stop the picket line.